Today we're speaking about generative AI and the law. I'm your host, Clare Lewis. I'm joining here today with Janet Peyton. I am a corporate partner in our Charlottesville office, and I represent independent sponsors, private equity funds, emerging growth and middle market companies in connection with M&A, private equity, venture capital, as well as with privacy issues. And I'm CIPP certified, as well as Janet. I'll hand it over to Janet to introduce herself.
Thanks, Claire. Hi, I'm Janet Peyton. I'm an IP lawyer. I'm in the Richmond office at McGuireWoods, and I'm also a partner on the data privacy and security team, and SIP certified for the US as an information privacy professional. And we look forward to talking with you today about generative AI. And my presentation is going to be largely around the issues related to privacy and intellectual property. So Claire, I'm going to hand it back to you to kick off.
Thanks, Janet. Artificial intelligence has existed in some form for decades and gone through various cycles of adoption. We're now at a tipping point with evolution of AI as there have been significant recent developments in the field, with more and more enterprise applications emerging and no signs of development slowing down. As AI receives more notoriety and adoption in the business community due to recognition of the power of the technology, the generative AI revolution introduces more questions and increased scrutiny of how best to use tools like ChatGPT and other applications, both at home and in the workplace. A key issue generative AI users face, as this quote alludes to, is that generative AI tools can be unreliable, unsecure, or downright incorrect. The problem can introduce concerns about privacy, IP, inaccuracy, and bias, among other issues. Both artificial intelligence and generative AI rely on machine learning algorithms to obtain results. Generative AI aims to create new content, while the applications for artificial intelligence are much broader. Machine learning uses data and algorithms in an attempt to recreate the way humans think, improve accuracy over time, and use this knowledge to complete human-like tasks and processing requests. Generative AI in particular has grown in popularity in recent years as creators have begun to build applications to produce content and meet business and personal demands using emerging, powerful deep learning models. Generative AI can produce new content, including audio code, images, text, virtual simulations, videos, among other content. Generative AI can be used by companies in many different forms across customer service, sales and marketing, human resources, finance, SEO, and data analytics departments. As an example, generative AI for SEO can discover long-tail keywords with lower competition and assess market trends to create SEO-friendly content that aligns with user search intent and attracts more organic traffic and improves search engine rankings. In terms of UI UX, generative AI can assess visitor behavior and enumerate changes to the website structure and design to enhance the navigation and lower the bounce rate. A key trend in enterprise GAI is that some companies are even developing internal-only generative AI applications. McKinsey's Lily is a chatbot trained on internal data by McKinsey, and Lily is designed for use by employees to cut down on research time, search through documents, and improve efficiency. McKinsey reported that Lily answered over 50,000 questions in the 2 weeks after rolling out the chatbot. Other software providers have developed generative AI tools to market and sell to existing customers, including SAP's Joule, HubSpot's ChatSpot, and Adobe's Sensei Gen AI. Besides these standalone generative AI tools, many software companies also power certain features in their existing technologies using generative AI. In May of this year, Google announced several new features powered by generative AI, including the search generative experience and a new LLM called PalM2 for its chatbot. There are many potential benefits to using AI in the workplace, including increased efficiencies, enhanced employee output, better data analysis, hyper-tailored content, and more accurate decision-making. But like any other foundational technology, new issues and other possible areas of risk exist with generative AI, including potential unauthorized use or dissemination of confidential, proprietary, or personal information, employee compliance issues due to improper use of generative AI tools, bias in employment and management decisions, along with other potential employment law violations, errors and inaccuracies in work product that could lead to reputational harm, the loss of trade secret protection, which Janet will talk more about, and perpetuation of consumer fraud. Hand it over to you, Janet.
Thanks, Claire. So first, let's talk about privacy. In the world of privacy, and I'm speaking specifically about personally identifiable information and data sets that have personally identifiable information in them, AI is very attractive. It's very tempting from a technical standpoint to use AI to analyze personal data. And where we bump into privacy risk is if those uses conflict with policies that have been published or regulatory, whether statutes or industry regulations, that's where we can start to run into trouble. So the first question you want to ask, if there is any, opportunity to use AI for analyzing a data set that's made up of PII, personally identifiable information, and including PHI, right, which is personal health information, is where did it come from and under what terms was it collected? These days, it is typical that personal information was collected in the context of some kind of a privacy disclosure, a privacy policy on a website, or in the healthcare context, privacy disclosures are mandatory. And we've all seen those HIPAA disclosures when you go to the doctor that tell you what they're going to do with your information and how it will be handled carefully to keep it confidential and so on. So even where it's not mandatory, posting a privacy disclosure of some kind is a best practice, and many, many companies do it, even those that are not required to do it by law. The U.S. is a little bit behind the ball here compared to some of our other Western peers. Most Western countries do require a privacy disclosure for any collection of personal information. In the U.S., we have requirements that are industry specific, and we also have requirements at the state level. Since we don't have the equivalent of a federal privacy law the way that our friends in Europe do with GDPR, some states have sort of stepped into that breach. Congress has not been able to get a bill like that through, and they're not able to get much through, in fact. So states have jumped in, California being the first, and you're probably familiar with California's consumer privacy laws. There are a number of them now. They were the leader in this area, but there are a number of states that have followed, including Virginia, where I'm speaking to you from. We now have a consumer data privacy statute, and in fact, a total of 12 states have now passed bills like this, although quite a few of them are not yet in effect, but they're going into effect next year in 2025. And they require privacy disclosures to be on the websites of companies that are subject to those laws. So what kind of companies are those? Typically, they are for-profit companies. All of the state statutes, except one, exempt nonprofits and educational institutions. But if you are a for-profit, particularly a B2C kind of company, a consumer-facing company, those laws likely apply to your company, and you have to have a disclosure. So the question is, what does that disclosure say? And is what you're proposing to do with the data analysis going to violate what you said you would do or what you said you would not do in your privacy disclosure? So any company that's regulated by the FTC, which basically is any for-profit company in the US, if you have published a privacy policy, whether you had to or not, and then you use that data in a manner that's different, that contradicts what you said in your privacy policy, that is deemed to be a violation of Section 5 of the FTC Act, because it's effectively false advertising. A person may have shared their data with you because they are careful about data, they read your privacy policy, they decided they were comfortable with the limited uses you said you were going to use it for, and now you're doing something different, and that's misleading. So, number one question, where did it come from and what terms was it collected under? Was the use of the data contemplated for this, by the data subject, the person, at the time that it was collected? Could they have imagined that it would be used in this way by the circumstances under which it was collected? More and more statutes, and certainly the ones in Europe and Canada and places that are a little bit ahead of us on this topic, those statutes are taking into account what people should reasonably expect. The idea is moving toward allowing individuals to control their own data and to know what's going to happen to it and whether or not to say yes or no to allowing it to be used in those ways. So if this kind of use wasn't contemplated, you could run into a problem. Now, the other thing is it might have been collected from a third party. It might be that it's not that you had a web form on your homepage where it said, please fill in name, address, date of birth, and so on. It could be that your business is some kind of a vendor and you're receiving all kinds of data from customers for some particular purpose. And you're thinking, gosh, we have this huge data set. We could use this for something else. We could, data mine this for other really interesting things, and AI can help us do that. That's true. But there presumably is a contract with whatever parties shared that data with you, and typically a contract that has to do with personally identifying information will have some pretty strict confidentiality obligations in it. So the fact that you have it doesn't necessarily mean that you can do whatever you want with it. It's important to look not only at the terms under which it was collected, but also at any contracts that implicate it. And then there is a particular subset of data that may sometimes require even additional consents. So this idea began in Europe, where their idea of what's very sensitive was quite different than the idea we have in the US. In the US, we typically have always treated information like financial information, your social security number, that kind of thing, as being highly sensitive, confidential, because it could be used for identity theft. But in Europe, the most sensitive type of information that they are most concerned about being collected, data mined, used for other purposes is actually data about things like religion, race, sexual orientation, health information. And you can see why, if you think back, a little bit in European history, you don't have to go back too far to understand why the idea of collecting data sets and being able to mine for those types of indicators could really put people at risk. And so there's a higher standard for that type of information. And interestingly, many of our state statutes here in the US, including Virginia's, have adopted that standard for what is sensitive: race, religion, sexual orientation, health information, children's information. Those things require additional safeguards. Sometimes it's in the form of requiring an affirmative consent from the individual to use that data. So not just posting a privacy policy, but some actual affirmative action like clicking a checkbox or some other I agree type of button that gives them the opportunity to say, no, I don't want you to use the information about my religion in this way. So if you're interested in doing data analysis using AI, and it's going to impact those types of data, it's very important to look at any legal obligations that you might have that are specific to those kinds of sensitive data. So for this reason, if you think about inputting PII into AI tools, ask yourself whether you have the right to use it in that way and whether the data subject would imagine it, and also consider the type of data. So that's funny. I'm trying to forward here. There we go. Sorry. So, the solution to this, at least the solution that in the past many folks have used to say, I've got all this wonderful data and I want to do this amazing data analysis and data mining on it, is I'll de-identify it. I'll de-identify it first. And that way, nobody knows who the people are. And we can do the data analysis on the other data points without being able to link them to an individual person. Historically, this has been, and still today, this has been a very important tool in the toolbox of data analysts. But today, particularly with AI, scholars are now beginning to argue that there's no such thing as de-identification, because we're just getting smarter and smarter about how to use data sets to de-identify data in other data sets. So I'm just going to tell you a quick story. You may have heard this in the news some time ago, but it's such a good example. I have to repeat it. The former governor of Massachusetts, William Weld, put in place while he was governor a state insurance commission to look at health issues related to people of Massachusetts, but the data set that he had to work with was specifically health information about Massachusetts state employees. And what they did was they created a huge data set of health information, hospitalizations, all that kind of thing, conditions that people have, drugs that were used, and de-identified it, allegedly. And the governor assured the public that it was de-identified, but this data set was made public so that data analysts could do important health research on it. But during his tenure, the governor himself fell ill. He had actually collapsed at an event and was taken to the hospital. And a clever student at MIT saw this as an opportunity to demonstrate that de-identified data isn't always really de-identified. She purchased for $20 the voter roll data set that is available to the public, and this is how candidates running for office can find out all the people that live on, Maple Street and send them a flyer and so on. She purchased the data rolls for $20, and she used AI to compare that data set, early AI, to compare that data set to the public health information data set. And she identified the governor's medical records, and she sent them to him. So you can imagine that that was embarrassing. And it was a really important lesson in the fact that even if one data set is de-identified, if others have access to secondary data sets with different information about the same people in them, AI can be used to put those together and re-identify. So when you put into a privacy notice promising individuals your data is going to be de-identified, it's never going to be used, in any way that can be linked back to you. Be careful about promises like that, and don't be so sure that, in fact, that's true. The other issue with de-identification is that right now there isn't a standard definition for it. So I put up on the slide the definition that's in the Virginia Code now about de-identified data, because the consumer privacy law that we now have also has exceptions for de-identified data. And you can do things with de-identified data that you can't do with PII. So in Virginia, de-identified data just means data that cannot reasonably be linked to an identified or identifiable natural person or a device that's associated with them, like a cell phone or a IP address. Well, what can and cannot reasonably be linked 2 years ago is different than what can and cannot reasonably be linked today. And this is another place where it's really important to look at your corporate business models. Is it the case that something that you felt very comfortable a few years ago was completely de-identified data, in fact, now can reasonably be linked to an identified or identifiable person? HIPAA, for example, has a totally different definition. It's got two separate definitions, in fact, about what's de-identified. It can either be deemed de-identified by experts that use scientific and statistical methods, or it can be deemed de-identified by ensuring it excludes 18 specific things. And so specific things like date of birth or place of birth, age, those kinds of factors, and there's a list of 18 of them. If you remove all of them, then under HIPAA, you should be in a position to say that the information is de-identified. But again, I don't think it's going to be long before someone could take a data set that is fully de-identified under this HIPAA standard and match it with another one and re-identify everyone in it. And obviously the risk there is bad actors re-identifying data. If data can be re-identified for purposes that are, threatening to public safety, threatening to personal privacy, or threatening from a corporate standpoint, then obviously there is a lot of risk relying on it. I don't have the answer for this. I just bring it to your attention to say de-identification is not necessarily the answer. So now let's just talk a little bit about intellectual property and how intellectual property rights can be put at risk in the context of AI. So the first thing I want to talk about is copyright. And I'll just take a minute, assuming that most folks that are listening today are not IP lawyers. I'll just remind you what copyright is. Copyright is not a trademark. It's not a brand. Copyright is the right of an author or a creator of any original work. It could be art, music, a sound recording. It could be code, source code, or text. Classic copyright is a book. Copyright is the right of the author to that work and to control who can copy it and what purposes that is used for in the form of a license. Typically, if you're the owner of the copyright, you can license others to do things with it, like translate it, for example. That's a right that the author or the owner of the copyright owns. AI comes in and tinkers with this because two reasons. One is works that are created by AI are not protected by copyright because AI is not a person. And there is actually some fairly good case law. We're lacking case law to a great extent in the world of AI. But this point has already been made pretty clear and reinforced by several courts. And that is that if something is generated by ChatGPT, for example, you tell GPT, write me an essay about, Lewis and Clark. That is not a work that you own the copyright in. And in fact, no one does. So when you're thinking about using generative AI to write original work, so to speak, or, to write work that is creative in some way, ask yourself if you care about whether or not you own the copyright. And the industry that you're in is going to really probably have an impact on whether or not you care, because if you're a professor and you're writing a textbook, then your publisher certainly cares about the fact that that work is original and they want to own the copyright in it, and that's why they can charge students hundreds and hundreds of dollars to buy it at the bookstore, right? But if what you need created is a simple form that, let's say you're a realtor and you want to have people fill out their name and address and information about what they're looking for in a home, and you just want to tell ChatGPT, make me a nice form. You probably don't care. You probably don't care if you own the copyright in that form. But this is such an important question, and I think folks are getting way out in front using ChatGPT to write things and not realizing that they may be losing the opportunity to own the finished work product. Then the opposite risk, the other side of the coin, is generative AI uses, as Claire said, large language models to generate quote unquote new content. But really, what that means is that it has ingested all of this information from articles in newspapers, from books, from things on the internet, website content, all those things. But all of those things are protected by copyright. And in fact, probably the vast majority of that work was not sought by the AI, coders to receive a license and put it into their system in a copyright licensed way. So we bump up against here something that comes up all the time in life and in business, which is the misunderstanding that if something is available on the internet, if you can get to it, if you can read it, that you have the right to copy it. And that's just not true. You don't have the right to copy books, music, articles, anything that you find on the internet. And we all know that the big engines like YouTube and Facebook and Instagram and so on spend a whole lot of time taking down things that people post that they shouldn't have because they don't own them. They don't have the right to post them. So here, if large language models contain a whole lot of potentially infringing material, and then you're going to use that to generate something for your business, there is risk that it contains infringing material. So not only are you not going to own it, but you may be infringing someone else. And there is right now a very interesting case. We're going to see how this develops. Some very well-known authors, including people like John Grisham, are members of this group that have brought a federal lawsuit against OpenAI because their works were ingested into the large language model without their permission. That's their argument. I wish I could tell you how that's going to come out. I don't know yet. But anyway, and then the last thing I would say about copyright with respect to works that are coming out of ChatGPT or other generative AI models is, what if you wrote it yourself? What if you did write the essay about Lewis and Clark, but then you put it in and say, make this better? Because one of the things that AI is quite good at is taking your dull essay and punching it up for you. Put it in ChatGPT and tell it, use more active language, make it more interesting and colorful, and use adjectives and so on. And then you'll get back an essay that probably does seem better. That seems like a better edited version of what you put in. So then who owns the copyright in that? Because you owned the copyright in your original work, the work that you put into ChatGPT. But what comes out isn't quite your work product anymore. It's a modified version. It's what we call a derivative of it. So while you own the copyright in the original, you may not own it in the derivative. These are all questions for the next crop of law students that are coming along at this very interesting time. So now let's move on to trade secrets. Trade secrets are another type of intellectual property. So the four major types of intellectual property are trademarks, copyrights, trade secrets, and patents. And there is a relationship between trade secrets and patents, which we'll talk about. But trade secrets are, by definition, secret. And the only way they have any value is by being secret. Their economic value is the fact of others not knowing. In fact, importantly, competitors not knowing what the secret is. So most famous trade secret in the world is the recipe for Coca-Cola, right? That recipe has been kept under lock and key in two separate safes with half and half, and only a very, very small handful of people have access to one or the other. And therefore, it's a valuable trade secret. And if you sue over trade secret, someone had access to your trade secrets and used them, like an employee stealing secrets from one company and then going to another. The way that those lawsuits play out is that first you prove it was a trade secret by how carefully you kept it secret. You prove that you had policies in place to keep it secret, that you always had confidentiality obligations on anyone that was going to touch it, that it was never shared with anyone that wasn't subject to those obligations, and so on. So, if you can't show that, that's where you're going to lose trade secret as an asset. Whereas the other kinds of IP, like trademarks and copyrights and patents, get registered. They're public. Anyone can look them up in the U.S. Patent and Trademark Office or at the U.S. Copyright Office and see the work, but it's protected because it's registered. Trade secrets are funny in that you would never want to register them because registering them would make them public. And this is where there's an intersection with patent, because until you apply for a patent, until you file your patent application, that invention needs to be a secret. It needs to be a trade secret. And once you file, you're basically trading off with the patent office and with the world the ability for others to see it, to understand the invention, to be told exactly how to do it. But you're trading off for a limited monopoly. So for a period of time while the patent's in place, and patents don't last very long, 20 years at the longest. So while it's in place, you have a monopoly, but at some point in the future, you're going to lose it. The patent will expire and the whole world has the right to copy it at that point. So where AI comes in is if people, for example, put code into AI, proprietary secret source code, but you want to use AI to search it for errors, where is it going? You could very easily lose trade secret, and there have been very high profile cases of this happening to companies where they didn't think about the fact, the coders didn't think about the fact that if they put this into a generative AI model and there are no limitations on the code learning from it and so on, you've immediately lost your right to claim that that's a trade secret. And so that can be a really significant loss. So I'm going to hand it back to Claire to talk about inaccuracy and bias now.
So as we've discussed, AI models learn by analyzing data sets, and faulty or biased data can lead to two major problems we'll talk about, which is that the outputs can lead to inaccurate results or embedded biases. The training model for most generative AI applications contains an inherent flaw in that the outputs are wholly dependent on the training data to teach the models the correct responses. So garbage in, garbage out. Bias can be introduced in this context. There are a few different types of bias we'll talk about. General bias would be if the data is the product of existing prejudices or social inequities, the AI model may perpetuate and even amplify these biases. And this can result in a system that discriminates or makes unfair predictions or recommendations. So for example, if an AI hiring system is trained on data from successful applicants who are predominantly of a certain gender or ethnicity, it may unfairly favor applicants of that group. There are also risks of unintended bias, which can arise from the unintended consequences of prioritizing certain features for evaluation of the model or the algorithm's analysis of the inputs. So an example is that certain features might seem neutral, such as years of work experience, but that could unintentionally disadvantage younger applicants or those who've taken leaves from work, like parents who've taken parental leave. Finally, there's proxy discrimination, which can arise when systems use variables that serve as proxies or stand-ins for protected characteristics like race or gender, leading to indirect discrimination. You might use a zip code as a factor in hiring decisions, which could unintentionally disfavor certain individuals and be closely correlated with race or socioeconomic status. An adverse impact will likely violate Title IX of the EEOC, and selection tools cannot discriminate on a basis prohibited under Title VII, race, color, religion, sex, and national origin. So if you use vendors' decision-making tools, particularly with respect to hiring, ask them if they've done a bias audit on their selection tools. While the risks of inaccuracy and bias may be simple to identify, the lack of transparency in how those models make their decisions makes fixing these problems difficult. AI models, and particularly the deep learning models, relied upon by many generative AI applications are referred to as black boxes because their internal workings are complex and difficult to interpret. The training data used by generative AI models is susceptible to two major problems in their algorithmic design: underfitted and overfitted data. Underfitting the data occurs when the generative AI has too little information to extrapolate correctly into new situations. And this can lead to little predictive power or predictive power with biases. So for example, in the graph on the screen, a data set with these inputs would potentially have too many points significantly distant from the regression line to predict useful future data points. The opposite of underfitting the data, overfitting the data occurs when an AI algorithm has too many significant variables, so the prediction line may closely match the input data, but the AI can no longer generalize effectively or extend its predictive power to new situations. So here, the prediction line shown merely connects the original data and doesn't uncover general trends that extend beyond the input data, which can lead to AI with little predictive power. Due to problems like underfitting and overfitting the data, generative AI is susceptible to issues such as inaccuracy and bias. And errors in these data can be difficult to identify and correct. So, for example, the problem of hallucination can occur when an LLM isn't capable of determining the accuracy of an output, but it still predicts the answer based on the highest probability of responding to a prompt successfully. So while the answer may be incorrect based on this triangulation, the model doesn't show any signs of wavering. It seems highly confident. In this context, an employee may erroneously rely on the answer because the response really appears accurate and authoritative. So, for example, if an LLM was not properly trained on an organization's PTO policies, the LLM may confidently assert that the company's PTO policy reflects an average or aggregate of PTO policies available in the collected data. Or the LLM may pull from a specific PTO policy found elsewhere, leading to an inaccurate answer for the prompt. Companies can't afford to ignore generative AI. Instead, they need to evaluate the issues that are presented to their organization. In response, company policies can seek to identify and limit the exposure and impact of these risks. Company policies allow an organization to remain flexible and adaptive in their approach to generative AI, so their risk profile and tolerances change over time. The starting point for designing and implementing effective generative AI policies is to comply with the law. So, for example, the Fair Credit Reporting Act and Equal Credit Opportunity Act set out certain obligations that companies have in protecting the information of users and clients, which can impact how employees can and should interact with generative AI applications. The FTC and state attorneys general, meanwhile, have enforcement powers against unfair or deceptive trade practices. Organizations have to ensure that GII is compliant with such laws. And fairness is generally a substantial inquiry, not reasonably avoidable by consumers, and not outweighed by countervailing benefits to consumers. So perpetuating racial discrimination through generative AI can be considered an unfair or deceptive trade practice. At the state level, there are many privacy laws specifically to regulate how AI can be used in the hiring context, such as the Illinois Artificial Intelligence Video Interview Act. California also has a chatbot law that requires, among other things, that in certain consumer interactions, a company provide clear and conspicuous disclosure that the consumer is interacting with a chatbot instead of a human being. And we should expect more regulation of generative AI in the future. The policies to reduce generative AI risk can take many forms, and certain key guidelines will include prohibiting confidential proprietary information, personal information, passwords, or other sensitive information from being inputted into an AI tool. Any work product that has the potential of being claimed in a patent application should not be used in AI-generated work, and companies should be prohibited from relying solely on such generative AI to complete the work. It's good to understand how the AI tools use the inputted information, require work logs or other internal tracking of GI use, establish a process for regularly reviewing and updating policies to keep pace with the evolving technologies and legal requirements and best practices. And lastly, implement a system for monitoring employees' use of GAI tools and enforcing company policies. Your policy solution should include periodic audits and automated monitoring systems and other mechanisms. The first step in preventing inaccuracy and bias in generative AI use is to carefully select which tools your company permits your employees and outside vendors to use based on their accuracy and error rates. These decisions can consider the implication of error rates and false negative and positive rates, then permit usages based on acceptable accuracy rates for the tool's intended use. So, for example, you may want to only permit the use of GI applications with satisfactory bias audit procedures. You can then restrict use as appropriate and require the input and output logs to monitor what information is being used in the generative AI applications and clearly state the consequences associated with those policy violations.
Claire, I'll jump in to go over a couple of the policy recommendations that are really specific to privacy and IP. So as we talked about earlier, if you are going to use AI to analyze de-identified data, to analyze PII, but presumably de-identified PII, put it in your notice. Make sure that your privacy policy is clear about what you do, both with identified PII and with de-identified PII. And think about the states that your consumers are coming from. If you're a, huge corporation with consumers all over the United States, you're going to need to be sure that your privacy policy has the required disclosures for California, the required disclosures for Virginia, the required disclosures for Colorado, and so on and so on. The other thing is to implement policies about data minimization. This is an overall privacy principle that don't keep what you don't need. It will also help you reduce your risk just in terms of data breach, because if you have huge data sets that you don't need anymore that have PII in them, you're just a sitting duck for a threat actor to try to come in and grab that data. Many companies, for example, keep HR data forever. And that just creates a huge gold mine for a threat actor to come into your network and take it. So if you have data sets that are not needed, get rid of them. And most people do this through things like document retention policies that say, employees that have left the company, their data is only held for X number of years, and after that, it's deleted. Doing things like that will help you not only avoid the risk of data breach, but also in the AI context, limit the availability of data sets to which someone could compare a supposedly de-identified data set. Look at your contracts and consider how your contracts should be modified to address AI. For example, if you're hiring vendors to do creative writing for you, do you want to permit them to use AI? If you don't say what you want, it is very possible that they will use AI. And even if the contract that you have with them says that they're assigning the copyrights to you, there may not be a copyright to assign, as we talked about. So if you're in the kind of business where you care about owning that work product from your vendors in the copyright context, put in the contract that they cannot use generative AI for those purposes. Similarly, in employment contracts, if you're hiring someone internally to do creative work for you, consider whether you are going to allow the use of AI. And if you are, be very specific about how it can and cannot be used. For example, some companies feel strongly that, AI has some great uses and purposes and they want their employees to be able to use it, but they want to be sure that the ability for the AI tool to learn from the data that's put in is turned off. And there are tools that offer you that choice. Even ChatGPT has a choice where you can turn off learning. It can be somewhat difficult to find, but it is there. So if you want to say, you cannot ingest what I'm giving you to use it for other people, just take my essay on Lewis and Clark, give me back a better essay, but then the original is not part of your large language model. That's something to consider. And if you're vetting AI tools, look for the ones that give you lots of choices. The ones that will allow you to say, don't learn from what I put in, can be very valuable. And then if you are going to use sophisticated AI for sensitive data and you know what you're doing, you are fully aware of the learning tools aspect of it, you've turned those things off. The other thing you really just want to look for is actual data security. Is the tool encrypted? Is the data going to be encrypted both in transition and at rest? Because that will go a long way toward protecting those sensitive data sets, even if all the other tools have been turned off or are being used in a safe manner. If the data can be stolen while it's in the tool, it's not safe. So that's a really important thing to consider putting into any contract that has to do with the use of AI and data sets with PII in them. So I think Claire's going to run through now a couple of example policies. Claire?
Thanks, Janet. So the first policy we'll talk about is a general use policy, which is intended to outline the general permitted uses of a generative AI tool and its applications. The policy is intended to be broad and can be tailored to your company's risk tolerance. So as seen here, you might outline in this section the routine workplace activities for which generative AI and related tools may not be used. This list can coincide with the prohibited use policy, which we'll discuss next. But a specific use policy could also exist alongside the general use policy, which would provide for the specific uses in which generative AI and the related tools could be used without further limitations. A specific use policy or a prohibited use policy could be used to place the restrictions that you want on the types of tools and applications that you see as the riskiest. A prohibited use policy might ban specific applications or tools that have bad reputations for privacy breaches, confidentiality, or output concerns. As seen in the final provision here, a catch-all in this section can serve as an important role by acting as a backstop to prohibit any generative AI uses that would otherwise violate other company policies. Related to the general use policy, specific use policy, and prohibited use policy, a reporting policy ensures that there are adequate channels of communication between your legal and compliance team and employees. Employees should alert the organization of any breaches of a policy, breach of data privacy or security, system failure, or an instance of a known inaccurate or biased output. It can be helpful to have these AI policies, reporting procedures, and documentation if a governmental agency or outside party conducts an audit of your practices or historical uses of the technology you have. And you may seek to further expound upon the corrective measures to be taken in case of a policy violation, which can be adjusted depending on the type of business you're engaged in and the inherent risks of a potential breach. Apart from creating new policies, you might also want to incorporate language into existing computer or electronic systems to govern the use of the generative AI. And this may apply to policies on electronic communications or computers, such as an internet policy or other system policy. We're still in the early days of generative AI adoption and usage, and it's going to be critical for your company to continue monitoring future generative AI uses and policy decisions and act swiftly and decisively to adjust the policies and implement new ones to protect your employers, customers, vendors, and data. As discussed previously, many companies are beginning to adopt and develop internal generative AI assistants and chatbots. So if you are developing one of those, the accuracy of those tools are crucial for the success and sustainability of your company, as employees will interact with these tools on a daily basis to answer questions, produce content and analysis, and complete tasks. And there are risks that companies should recognize in the use of these internal generative AI assistants, which can be training on the wrong data, unapproved access to confidential employee or client information, plain inaccuracies or hallucinations, or employee reliance without double checking the facts. In response to these risks, a company may seek to tailor its general use, prohibited use, and reporting policies to the nature of any internal generative AI assistants, with the goal of clearly outlining how these tools should and should not be used by employees. Generative AI can serve as an assistant to recruiters, take care of rote and repetitive tasks like writing a job description, read resumes, screen applicants, and assist in the hiring process generally. But generative AI hiring assistants present several risks related to the discriminatory results and biases. Because of these risks, use of this technology has come under regulatory scrutiny from certain state and federal authorities. For example, in New York, beginning earlier this year, the Automated Employment Decision Tools Law makes it unlawful for an employer or an employment agency to use an automated employment decision tool to screen a candidate or employee for an employment decision unless such tool has been the subject of a bias audit, like we talked about, and that has to be conducted no more than 1 year prior to the use of the tool, and a summary of the results of the most recent bias audit of that tool, as well as the distribution date of the tool. And it needs to be made publicly available on the website. On the policy side, you may seek to limit or wall off access to certain internal files or systems, or prohibit any tools that lack a bias audit or require additional vetting of results produced by generative AI to prevent sort of wholesale reliance on them by the hiring decision makers. So in conclusion, and then we'll hit on Q&A, the practice tips that we have here are: strict data permissions can limit which users have access to confidential, proprietary, or protected information. And this can include limiting what type of information a generative AI tool can access on its own. You want to always ensure users review and verify outputs from GAI tools to ensure the accuracy and confidential nature of the results. As generative AI continues to grow in adoption, you want to stay on top of the latest use cases and developments in the law. To further ensure compliance, a system to review and update GII policies periodically in response to changes is necessary. And finally, and then I'll hand it over to Janet to answer the Q&A. Equally important as your company's own GII policies and uses is to monitor how employees, your partners, and vendors are independently using GII and whether these uses create any risks for your organization. Janet, I think we had a question here which is related to IP. The question was, if I submit original copyrighted work to a generative AI for its learning, and the generative AI then outputs my language as a response to a question, would I keep copyright protection of it? I think you hit on this, but I'll let you expound upon it.
Yeah. So my answer is no, because what comes out is not, your creation. And I will say the way that AI works, typically it's not going to come out word for word the way that you wrote it. It's using what you wrote to learn, and it may use a significant piece of it, but output from AI does not have copyright, and therefore, you don't have the copyright in that work that's coming out of it. What I would suggest, in a situation like that, it's probably best just turn off the learning so that you can make use of the AI tool without it ingesting your work for its future, answering of questions and so on. It looks like the next question. Hi, Susan. The next question about telling the large learning model that it can't use. If you tell it that, does that make it possible to have copyright? I'm not sure that I understand the question, Susan, but maybe I just answered it. Anything that comes out, the answer is no. You're not going to have copyright in it if it was generated by AI. What the turning off of the learning does is to avoid the ingestion of your proprietary content into the model so that it's copying you and using your own copyrighted works for things that you didn't authorize. That's the reason to turn the learning off. As I said, John Grisham and this group of authors are mad that their books were ingested and learned from without their permission, because they're in the business of selling books. And if you can, use their book for some business purpose without paying, that's a violation of copyright. It looks like, oh, thanks. Susan says you did just answer it. And it looks like we also have a question about templates. So I think a few of the slides, Claire, at the end were intended as they're obviously not full template contracts, but those give you the ideas of things that ought to go into those kinds of agreements. And obviously, we're in the business of helping draft, not using AI, helping you, draft policies, and we're happy to do that if you would like some help. Oh, now here's an interesting one about the question from Julian is, like in music copyright law, is there a sample allowance whereby a text significantly short is exempted from copyright? So I think what you're getting at is the concept of fair use. But people misunderstand fair use all the time. Fair use is a defense to copyright infringement. And the only way you know for sure that you have fair use is when a court decides that you do, because you've been sued for infringement and you're claiming, but it was fair use. So it's sort of like the defense of, self-defense in a murder case. The person is dead. They were killed, but you're saying, but I'm not liable for it because it was self-defense. The fair use doctrine says that there are 4 factors about copyrighted works, and if your use of the copyrighted work falls in favor of fair use with those 4 factors, and they are things like the economic benefit to the author or copyright owner is unaffected, the work was substantially transformed into something else that's new and creative, and one of the 4 is the one you mentioned, the size, the amount of the whole of the copyrighted work. So if you just took a sentence or 2, then that weighs in favor of a finding of fair use. But it's not the only factor. And, as I said, things that come out of AI are not protected by copyright. So really, it doesn't matter if it's a large amount or a small amount. If it's coming out, it's not going to be protected. I'm not sure that answered the question, but I'm happy to follow up, and you'll have our emails, and all of that is available on the bio page at the beginning of the presentation. And I think our team is planning to send a copy of the presentation to everyone who was registered today. So you'll have all that information. And yes, the slides will be shared. So thanks so much for joining us.